I'm here on Emma Lynch. She's got a bond violation. You wanted to talk to her.
Okay, do you mind bringing her up?
Yes, Miss Lynch. When we were here last time, you ordered her to have the interlock installed on her vehicle. She is not driving the vehicle. It's not drivable. We just need to switch her to a portable.
Oh, no.
And a no driver.
She has nothing. And it doesn't matter. We ordered you to have an interlock in a car. You haven't done anything and you're without any kind of devices whatsoever, right?
That was totaled and it's at my house right now, but I don't have I'm in a rental car that I'm not driving, so I don't have a car to put it in.
So you have no device.
That's correct.
You're not being monitored.
That's correct.
Let's break this down. The judge ordered a court-monitored interlock device, basically a breathalyzer for your car, and she never installed it. Why? No car. But here's the kicker: not having a car doesn't excuse you from a court order. You still need to show up, explain, request alternatives. What do you think? Should she be held accountable, or does the no car excuse hold up? Let us know in the comments.
This is not a good thing, Miss Lynch, because I ordered you to have a device. And from what I understand here, you never even went and got it.
It's because she doesn't have a vehicle to put it on.
But you come back and you say, hey, judge, I don't have a vehicle. I need to do something else. You just don't, out of sight, out of mind. That's not the way things work.
Judge, for that violation as well, we instructed her in court and sent a message for her to report to 49 following court to get further instruction over everything so that we could figure out things from there, and she never reported.
Stephen, Miss Lynch, you haven't done anything. They've literally bent over backwards to help you and do stuff, and you haven't done anything.
I wanted to come in today.
The only reason you're here today is because I ordered you here
Yes,
today.
sir. Yes, sir.
She goes with you.
Yes, sir.
Emailed, texted, call, nothing, you know?
I understand. Would you consider setting her a new bond or do you?
Of course, 5,001. And then, you know, if she's unable to, then what's today, Friday, Monday, then we can talk. Okay?
That makes sense.
Yes, ma'am. Thanks. Okay. Corey.
Judge.
Hey, good morning.
Got Mr. Adams, Derek Adams.
Okay.
It's
It's a really old case.
yes,
I've told him it's time to put this baby to bed.
yes.
Is there an offer in this case?
No.
How come after 1,258 days, there is no offer?
Well, 258 days and still no offer? That's nearly 3.5 years. And the judge isn't having it. Notice the tone shift? This is no longer about negotiation, this is about accountability. And when she says, get on it now, you can feel the courtroom's tension skyrocket.
Hoping we can get a gun safety class and dismiss.
It appears that was
Come on,
probably,
Mr. Adams.
the delay is probably due to the missing dash cam that's still outstanding that we do not have.
I don't care.
Yes, Judge.
Get on it now.
Yes, Judge.
Why on earth would we allow you to do this class where you get to dismiss this case when it's 1,258 days and you've repeatedly taken off? It's a rhetorical question. You don't have to answer it. But I'm telling you now, I'm giving you 2 weeks to decide what to do with this case. The next time you come here, you will either accept a plea bargain agreement or I'm setting your case for trial. Do you understand? Not only that, I'm putting an ankle monitor on your ankle now so I know where you are at all times. Do you understand, Mr. Adams? And the next time you take off, I'm going to make your bond so high you're going to have teeth falling out. Do you understand?
Judge, if I may, my client, shortly after this arrest, he lost his mother, and I believe it's the mother of one of his children.
No, my sister.
Sister. He fell on hard times. He was already, not well employed. And he's been through some rough times in his life in the past few years. He recently got a job working at a Chinese restaurant, and he has 3 children that he helps take care of. I'm not exactly sure when his last failure to appear was. It might have only been 1, but he hasn't been in trouble since this arrest, I think in 2021, right? So I asked the court to withhold from, giving him an ankle monitor. The state's also missing evidence here. If we can come back and.
Last time we saw him was 3 years ago, Corey. So, I have sympathy in the fact that everybody has hard times, but your failure to appear on a repeated basis is a constant kick in the ding ding to us, and I'm not going to take it. And I'm going to tell you now, I don't know why your bond is not at 10,003, because that is what it really should be. Your bond is at 1,002, and it's way off of what it normally would be. Because I'm telling you, your bond should be 10,003, because that's what they're normally set with a person who has absconded as many times as you do now. You're lucky that you're not in custody as it is now. Do you understand? But at 1,258 days, I don't trust you. And so the only way I know that I'm going to keep tabs on you is with an ankle monitor. And like I said, the next time you take off, and it doesn't matter what the excuse is, the bond is going to go astronomical. Do you understand, Corey? I'm sorry, but if it were maybe 500, maybe 300, I would relent on not putting a monitor. But at 4 years or however long this case is, hell no.
I think that reflects his law abiding.
So here's the deal. The defendant walks out today, but with a GPS ankle monitor, and the judge is covering the cost. Why? Because she doesn't want any excuses. This is courtroom accountability at its peak, mercy paired with a warning question. For you, is this a fair compromise or too soft considering the 4-year delay?
Right, that he hasn't been in trouble, had any interactions with the police.
How do I know that?
Well, yes.
I don't know.
He hasn't been, he would have been in an orange jumpsuit, I guess, if he
Not
had to.
necessarily. I mean, we don't know how he's been out of county, out of state. Look, you're walking out of here now. You're getting 2 weeks to decide what to do. You're not going into custody now. So you're still walking out of here, but I'm putting a monitor on you. And I'm telling you something else, that I should make you pay for it, where it would cost you around $400 to $500 a month, but I'm going to eat it. So there's no excuse. Do you understand, Ms. Adams? But you got to understand that in court, we hold people accountable. You may be able to live your life like this outside of the free world, but not in court. We will hold you accountable. And the next time, get ready. Take a seat. Of course.
Judge, for information,
Hey,
I have some from-
expedite it, whatever you need to do to get that.